Does anybody have any questions? Or does anybody... Yes?
Tim, the 4 points that you've made there are pretty clear. They seem to leave out a big part that the legislation currently covers, and that's building regulation.
That is, so far has proved to be largely uncontroversial in submissions to us. There has been a deal of discussion about whether we should recommend reverting to something more akin to the DA-BA process that applied in the past. I'm not sure the extent to which things like the impact of the Building Code of Australia and the like is appropriate, nor has there been... there will be material dealing with certification and the like, but I am not sure the extent to which we will need to get into the question of the details of building regulation.
Tim, on that very subject, there is some controversy about building regulation, and just giving the heads up, there will be a submission made to your team on this subject, and it'll propose some reform take place.
Oh, well, if there's a submission made, we will undoubtedly deal with it in the issues paper, and then in light of whatever responses come to the issues, we will deal with it then in our recommendations. I haven't planted this question.
No,
I've been working with this lad for a while.
The first bit of the Act is probably going to have to be the objectives of the Act. And as you know, the court has quite often tried to drag the objectives into the assessment process. And there's a lot of discussion about the objectives. How are you going to look at approaching the objectives? Because really that goes beyond the way that the pipeline might work. It's about the objectives for the pipeline.
No, we have had, so far in the stakeholder discussions in Sydney, at least I would guess 10 to a dozen new objectives suggested as being appropriate to be incorporated. If one looks at the material that is currently contained in the objective section of the Act, it is written in language which is perhaps not contemporary and certainly not necessarily plain English drafting, which is one of the aspirations we have for the outcome of what we're doing. And I think there is no doubt that we will need to make some fairly detailed submission about what the objectives look like. We may even have a go at drafting some. For example, although many would say that the precautionary principle is automatically enlivened by the concept of ecologically sustainable development, there has been a suggestion that there should be a separate and specific enumeration of the precautionary principle, and those are matters that undoubtedly we'll be giving a deal of attention to. Gentleman down the front was next.
Did the Premier or has the government given any sort of overarching instructions on what is expected to come from the review, or is it simply a refreshment of the process?
No, we've been given one overarching instruction and one overarching instruction only, and that's by the Minister, and that is that one of the outcomes is to be a maximisation of the amount of information available about any parcel of land in New South Wales electronically through a simple-to-use portal, and to maximise the use of information technology in plan, lodgement and assessment. We have been given no broader merit or ideological instructions whatsoever, except to say they wish the system to be simpler and in effect for us to rewrite it from the beginning. Yeah.
If I could just add to that, we have no formal terms of reference at all. Inquiries or reviews commonly do have. Well, it's not the case here. However, various wishes or suggestions had been made by the Minister, including the one to which Tim has just referred to. However, I think underlying the whole exercise is the fact that the existing legislation has been in force for some 30 years, which clearly is a long time. Over that period, some 400 amendments have been made to the Act. Amendments occur something in the order of 3 or 4 times a year. So clearly, the current legislation, with the passage of time and governments coming into office and going out of office, has become something of a patchwork. So it doesn't need really for formal terms of reference to be specified to know that the Minister does want a contemporary piece of legislation that takes account of developments that have occurred over that 30-year period.
Yeah.
I guess with what you've just said, the issue of standardised planning schemes, across the state and simplification, obviously that's going to be a big part of your review.
One of the matters that has been raised by a number of people who've spoken to us so far is, I think, what we might delicately describe as a number of areas of dissatisfaction with the standard instrument, both as to the speed of rollout of local environment plans in adopting it, and some concerns about flexibility in its terms, both as to its terms and to the way the zoning is drawn under it. They are matters that we will have to deal with, but there is certainly no support has been put to us by anybody across the spectrum to date that the standard instrument process should be abolished.
Are you looking at what's happening in other jurisdictions as well as in New South Wales, like say Victoria or overseas?
We expect after the completion of this stage and before then that we will be visiting Victoria, Queensland and talking to the ACT government, although the ACT government will largely be about cross-border development issues with New South Wales. Whilst several people from development-related organisations have suggested that there are other places that we should go to, the planning system in Paris is apparently particularly useful to be studied in spring. Although I have known the Minister for a very long period of time, I doubt that he would be attracted to such a proposition. We also wish to say, as far as we are concerned, all information that is given to us is public. We are putting notes of all of the stakeholder meetings that we are having, and we will be putting notes of all of the community consultation forums on our website. It is to be, pardon me, an entirely transparent process. It will be in common with normal submission processes, one where if there is a particular reason why a person wishes to provide their personal details to us only and not make them public, why that is going to be possible, as is the case with people who lodge submissions with the department, I understand it. I say that in case any of you might wish to make a submission and to do so in circumstances where you wish your views to be known to us, but not the fact that your views have been made known to us being made to those of your colleagues or superiors in the department who might not agree with what you're saying. I need to make this quite clear, we are entirely independent of the department. We are getting very valuable support, both in a sort of pay and ration sense and in a note-taking support through Rosemary and through Liz Land, but we are deliberately parked in Siberia in the close to the outer darkness on the ground floor. We are separate from the institution, and our activities and indeed any of that sort of material, if people wish to give it to us on the basis that their identity is known to us and not to anybody else, that will be respected. And although we will not accept anonymous submissions where a person makes their identity known to us but not to the world, is a proper and legitimate part of us receiving material to inform ourselves about the matters that we need to consider.
If someone who works for the department wants to make a submission and doesn't want that to be published as, I suppose, a department's view, but rather as a personal view, can we state, or can I state, that I would prefer that it wasn't made public? Or?
Well, you can state it and it'll get sent back to you. Anything that is said to us is on the record. We are prepared to protect the identity of those who say it, but we will not receive material that is not available for public scrutiny. Okay? So we've got a separate email address, which is review@planningreview.nsw.gov.au, and if somebody sends us a submission that doesn't disclose their name and details in the document, and in the covering email says, I am X, I am an officer of the department and I do not want my identity disclosed, we will simply put that up as a submission that says the identity of the person making the submission has been told to us. We are satisfied that it's a genuine submission, and we are therefore publishing the submission but not identifying the author. Does anybody else got any questions? Does anybody want to make a submission then while you're here?
Oh, just a question actually, not a submission. The matters that you consider, will they largely be limited to the things put forward in submissions, or might there be matters which you choose to go and research?
No, the document will make it clear that, firstly, we will reserve the right to reject matters as being outside anything we can reasonably be expected to consider. We have said that so far to a large number of people who have said, we want you to recommend amalgamation of local councils. Not going there. It's not only is it outside any conceivable interpretation of what we might think our terms of reference ought to be, it is beyond our courage levels in a Sir Humphrey-esque sense. And that will apply to other things that might be put to us. But we will identify and say we are not going there. Second, we will repeat those matters and identify them where questions arise from submissions that we think require to be put, and there may be either supplementary questions or indeed entirely new matters which we, of our own volition, believe should be put out as questions that require consideration during the course of the process. So, for example, nobody has yet said anything of any significant substance about the order-making powers under the Act, the enforcement provisions. It's undoubtedly a matter of some importance. It can't not be there unless it's put somewhere else, and we will undoubtedly have to pose some questions about order-making powers and the like. Whether or not we choose to let people know that they are all our ideas or somebody else's ideas is a matter that we have yet to contemplate. The document, I expect, will be written in a fairly neutral term. Any more questions? They put Mogadon in the water jug before you were allowed in. No? Right, thank you. Well, we do encourage you to make submissions if you wish to do so. There will be, I'm expecting, a formal departmental submission of some nature at some time, and I have already flagged to the Director General that at some time there are going to be some matters of how the department operates that we will wish to discuss with him so that we are properly informed and don't make erroneous or incomplete assumptions about things in posing questions about assessment and the like. Thank you for your attention.